time to attend. Today, I'm going to speak to you about some recent decisions, recent court decisions involving a company called WorkPack, and one of those is WorkPack and Rossato, and the other is WorkPack and Skeen. And basically, in my opinion, particularly the decision of WorkPack and Rossato is of cause for concern for employers throughout Australia. Peter, if you could go to the next slide, please.
Yeah, just before we kick off, guys, essentially, Ben's going to present to us for about 15 to 20 minutes, and then we'll have questions at the end of it. There is a chat box that you can type your questions into us as well. And also, there'll be a short survey at the end of the slides also to complete with any topics and that you might want to have further. This is the first of our monthly series, so we had quite a few webinars during COVID-19 just to keep everybody up to date. And now we're really going to look at doing a webinar every month. So next month we have Heron Todd White doing a property update. Sorry, that's in September. In August we have a market update. So we are looking to do these every month just to keep the educational piece up to date for all of us on a wide variety of topics as well. So Ben, I'll let you go with it. I'll share my screen, and you're right to kick off into the wide world of employee entitlements and casuals.
Thanks. Over to the next screen. Thanks, Brent.
Yep.
So the employers of Australia's 2.6 million casual workers now have a $14.2 billion bill hanging over their heads. This is because of as a result of the single decision of the federal court in WorkPack and Rossato. In its most basic form, the court has decided that a casual employee, Mr. Rossato, should have been classified as a permanent employee rather than a casual employee. And Mr. Rossato was awarded his unpaid work entitlements, his accrued and untaken annual personal and compassionate leave. And he was also permitted to keep the casual loading payments that his employer had made to him throughout his employment. Next slide, thanks, Pete. Next slide, yep. So permanent employees, whether full-time or part-time, are entitled to a set amount of employee entitlements. These entitlements include annual leave, sick leave, compassionate leave, long service leave, maternity leave, and permanent leave. In substitution of these entitlements, casual employees receive what is known as casual loading. This is a payment which is generally 25% above what their permanent colleagues earn. And it is given to casual employees in lieu of them receiving the permanent entitlements. Next slide, thanks, Pete. So how do you determine who is a casual employee? Unfortunately, this is not answered in a straightforward piece of legislation, so we have to turn to court decisions to help determine the criteria or test of casualness, so to speak. In essence, casual employees do not expect to receive regular work and have no firm advanced commitment that work will be available in the future. The judgment in the case of WorkPack and Skeen sets out a list of indicia to be considered in assessing whether or not an employee is employed on a casual basis. And I've got them listed there: no continuing and indefinite work, irregular work patterns, uncertainty of further work, discontinuity of work, intermittency of work, unpredictability of work, no commitment between employer to employee. Assessing whether or not an employee is a casual employee is a subjective process. The circumstances of each individual employee must be considered. The fact that there are lengthy judgments on this issue alone are testament to the fact that in some situations it can be difficult to determine whether or not an employee is a casual or not. Employers must also be wary of a hybrid classification that exists known as long-term casual. They can work a repetitive pattern of hours or days per week, and if this occurs over 12 months, they can be entitled to parental leave and flexible working arrangements. Next slide, thanks. Given the uncertainty surrounding the definition of a casual employee, there is no doubt that employers have gotten it wrong in the past and will continue to do so moving into the future. When a casual employee believes that he or she is actually employed on a permanent basis and the court agrees, an employee can seek compensation for unpaid permanent entitlements despite having received the casual leave loading. In 2018, lawmakers identified the potential for double dipping of casual loading payments and permanent employee entitlements. And to rectify this, a regulation 2.03A was inserted into the Fair Work regulations. This regulation was meant to protect employers in this situation. Casual loading paid to an employee would be taken into consideration in determining, in considering an order for compensation in circumstances where the employee was employed by employer on the basis that they were casual. The employer paid casual loading, and this amount was clearly identifiable as compensation for not having employee entitlements. And during the employee's employment, the employee was in fact not a casual, and the employee is making a claim the employee is making a claim to be paid an amount in lieu of their employee entitlements. Next slide, thanks. So the importance of work pattern scheme, which was decided in 2018, is twofold. The decision sets out a comprehensive set of indicia of casual employment, as previously discussed, and the decision prompted lawmakers to legislate that employers in certain circumstances could offset casual loading payments against amounts claimed for unpaid permanent employee entitlements. And this was that regulation 2.03A that I was talking about. However, in May 2020, WorkPac v Rossato was heard. A bit of background here. Rossato was employed by WorkPac, which is a labour hire company that focuses on the provision of employees in the mining industry. Between 2014 and 2018, Rossato worked as a casual field team member under 6 consecutive employment agreements at 2 mines in the northern part of Queensland Bowen Basin. In this case, Rossato sought to prove that although he was employed by WorkPac on a casual basis, he was actually a permanent employee during his employment and could therefore claim unpaid permanent employee entitlements. So after some 1,025 paragraphs of reasons given by the judges, Mr. Rossato was awarded unpaid permanent employee entitlements. And what is so controversial about this decision is that WorkPac was not allowed to set off this amount against any casual loading payments they had previously made to Rossato. From what we've previously discussed about the purpose of casual loading, this is a clear double dip. So why did the court not accept WorkPac's claim to have Rossato's casual loading offset against his award? of unpaid permanent entitlements. The main factors were element 2 of regulation 2.03A was not satisfied, as whilst Rossato's employment contract specified an hourly rate, it did not identify a portion of the hourly rate as compensation for Rossato not receiving permanent employee entitlements. And 2, element 4 of regulation 2.03A was not satisfied, as Rossato did not claim an amount in lieu of unpaid employee entitlements, but rather claimed the untaken entitlements themselves. This second deciding factor, that the employee's claim was not made for payment in lieu of unpaid employee entitlements, but rather for the untaken entitlements themselves, in my opinion, whilst technically correct, is an extremely technical interpretation of the regulation and goes against the intent of the lawmakers who originally enacted regulation 2.03A. The decision has effectively rendered the regulation obsolete. Employer groups are now rightfully calling for reform of this regulation. Pete, if you can change the slide, please. So let's quash some common myths associated with the work pack situation, or the decision, sorry. That employers can no longer have casual employees. This is false, but employers must now pay greater attention to the nature of each employee's employment and consider whether the indicia of casual employment listed in the case of work pack and scheme are satisfied in relation to each casual employee. And 2, that casual employees are entitled to the same entitlements as are permanent employees. This again is false. If an employee is a genuine casual employee and casual loading has correctly been paid, the casual employee will not be entitled to employee entitlements. This then brings us to the most important point of asking, what do the work pack cases mean? Well, firstly, if you've got a casual employee, a clearly identifiable amount of a casual employee's pay must be allocated to casual loading or an amount in lieu of permanent entitlements. This must be shown in the employee's contract and on pay slips. And secondly, the set-off legislation, regulation 2.03A, must be reformed. The technical decision of WorkPack and Rossato has, in my opinion, rendered the set-off regulation obsolete. Unless the regulation is amended shortly, we can expect a spate of claims against employers for unpaid employee entitlements. Next slide, please, Pete. Without surprise, WorkPack is appealing the decision to the High Court, with the Attorney General confirming that the government will also intervene in the High Court proceedings. Until we have clarification of where employers stand, employers cannot be complacent. Employers must consider their industrial relations arrangements. An assessment should be made as to whether those employees who are employed on a casual basis are in fact genuine casual employees. The indicia of casualness must be considered, and broadly speaking, those employees who are employed on a regular and systematic basis are not genuine casuals. This task, as I've said before, is subjective and, in my opinion, not a simple one. Employers must review the hours their employees work regularly and ask themselves, do our casual employees have a firm advance commitment regarding hours and days worked? And is there an expectation that they will have continuing and indefinite work? And has this happened for more than 12 months? If you as an employer do not have all of your employees on employment contracts, you should consider doing so. If your casuals are employed on employment contracts, ensure that the contracts specifically state the portion of the employee's hourly rate allocated to casual leave and paid in lieu of those entitlements that would be if the employee were employed on a permanent basis. Next slide, Brent. Thanks for your time. I invite any questions.
Stop my screen share, mate. Thanks for that, Ben. It was really interesting, even though, as you said, it was based off one, I guess, court decision. Is there any particular reason why WorkPac was involved in both of those cases? Just straight off the bat, is there any particular reason? Obviously, they do have a lot of casual employees. Were they a bit of a target in that case, or what were your thoughts on WorkPac being involved twice with regards to that?
I actually couldn't answer that. I don't know why. Sorry, mate.
Yeah, no, you're right. And the next thing is what if you have casual employees that work roughly a rough amount of hours each week, but the hours change and also the times change? For example, the McDonald's employee is obviously the easy one from there, but you can apply McDonald's employee to most businesses in some way, especially in hospitality. Are they really casuals if their hours and times and that are changing, or was that WorkPac case purely just for the casual employee that works 8 to 3 Monday to Friday?
Yeah, Rossato he had a, he was employed on a casual basis, but I think he had a roster going out 7 months. Okay, he had an expectation of regular, ongoing work. Okay.
Yeah.
And that's the key take from this, from my having a look at this issue is that, you've got to get it right in terms of, we're stuck with this case of Rossato at the moment. Okay, the decision there. As I said, that regulation 2.03A now is, in my opinion, obsolete. So if you misclassify an employee as a casual, and the employee is found to be a permanent, and you have paid leave loading of 25%, it's not going to help you. The employee, if they bring a claim and it's, they've got good lawyers who make the claim, not for payment in lieu, okay, but they say, I'm actually claiming my unpaid entitlements, which is what happened in Rossato. You're going to face basically an order or for unpaid entitlements going back, potentially 6 years.
See, back in 10, 15 years ago, a lot of professional firms, and I'm just looking at our attendance list here as well, a lot of people that were in professional firms or in, I guess, medical practice or office jobs, if you worked, say, 15 and 20 hours a week, you were casual even though you had that same set amount of hours all the time, didn't you really? And now the trend is, especially based on these cases, that if you do have someone in that sort of role, you really should be probably looking to put them on permanent. Is that your advice from there? If it looks like a permanent, is a permanent. Is that what you're trying to say?
Yeah, look, if they're working regular hours, 9 or 3, or regular rosters, okay. As I said, it is to be determined on a case-by-case basis. But if you're an employer and, you have employees that are long-term employees, longer than 12 months, they've been with you for years, they work the same rosters, they work Monday from 8 until 2, they work Tuesday from midday until 5. You really should be having a good look at that and getting advice, okay? Because as the law stands now, you may find yourself being sued and having to pay, unpaid leave, sick leave, long service leave, whatever, going back, however long the employee's been with you.
And you're recommending that employers really look at their employment contracts with their casual employees, but also all employees, really, they need to be reviewed regularly. But that's going to be the key to it if someone does come and ask a few questions. Is that right, mate?
Yeah, look, definitely. I think really having employment contracts is very important for, for reasons other than, just what we're talking about today. But I just think that the classification of the employees is the main thing. You've just got to get it right. And in my opinion, I've been asked to do this. Have people come in and we chat about it. And it's not straightforward in all situations. Sometimes it's really easy to determine whether or not somebody is a casual employee. Like the McDonald's staff, 1 shift a week, 2 shifts a week, they find out about their shift, on the Sunday night, that sort of stuff. They might go a week without getting work, but that it's a very important question to get right.
That's good. Does anybody else have any questions of Ben on this topic, or dare I say any topics that are topical at the moment? No. If there was one take, sorry.
Sorry. Ben, I've got a question. We have casuals that's working the same days and same hours for more than a year. They are on a casual basis. They are getting a fixed price plus the casual employee subside. How do you think, do they still qualify for casual or not really? They work roughly about 32 hours a fortnight.
How long have they been with you for, Anna Marie?
Since May last year.
So over a year. Look, I think, as I said, you need to, I think you really do need to sit down in that situation and, maybe go and have a chat with somebody, get a second opinion, okay? Have a second set of eyes, have a look at this with you, okay? How, like, for example, rostering, when do they find out? Do they know what their roster is?
Yes. The rosters is actually set up by themselves. So some of so they work every Monday, every Wednesday, and every Tuesday. Say from one work from 9 to 1, and the other one starts say 1 to 4. Just roughly. I'm not talking exactly the right hours, but that's just roughly. But we worked on that get paid for 32 hours because that was what we were told, that's the limited hours for a casual worker. Is that correct, per fortnight?
Look, it's I haven't seen anything that says anything about the number of hours, but these are some of the words that I've seen used. They regular work, systematic work. Is there an expectation of further work from the employer? And probably what you're telling me there is, there is regularity. It is system.
Yes, there is, definitely. There's a system, yeah.
It's systemized, and I would say that there may be an expectation of work. So, Anna Marie, what I would do in that situation is I would say to you that I think the arrangements that you have there need to be looked at, because those employees may be regarded as permanent part-time employees.
Okay, thank you very much.
Have you seen much that's come across your desk, Ben, at all, or is it just starting to gain some traction? I mean, we saw it come through our sources as far as our readings and things like that, and it popped up. So it's obviously been sent around the accountants and solicitors and things like that. But is it common knowledge out in the wider world at the moment, or not particularly? Not many people are talking about it yet?
Look, I think I haven't had anyone come in and make a claim against their employer, and I haven't had any employers come to me and say that claims have been made against them. But we act for a lot of employers, and we want to make sure that that our client base are aware of the risks. Okay, and we're just saying to people, you might be right, everything might be okay, but have a look at it and have a regular look at it. Okay, because before you know it, somebody who's been working on what you think is a casual basis has been with you for 18 months. And, if they get wind of this stuff and you have a falling out or whatever, you might find yourself in the same position as Workpac. Okay. So this bloke Rossato had been working there for 6 or 7 years. His employment had ended. Okay. He'd retired. And then, and then there's a claim for all of his unpaid entitlements over the last 6 years.
It's difficult when people go back that far, isn't it, really? That's really concerning.
Well, these claims, because you've got statute of limitations and all that. So, people, if they do get wind of this, undoubtedly there's going to be more and more claims. You've got class action law firms that, like to ring about and drum up business and all that. So, yeah, there's a few cases. Coles, I think, has got one. I've just got some notes here. Yeah, so there's Hero Sushi has been fined $891,000 for underpaying its workers. There's a class action, okay, against Coles for $150 million. An underpayment class action. So, you're starting to see a bit of this going on.
Yeah, so it doesn't take long for those sort of class action lawyers, especially from a big company.
Yeah, and
really
a small business, there's not a lot of surplus funds for most small businesses, and to be, copying claims from several employees, going back, 6 years or whatever, that's 4 weeks of annual leave every year, compassionate leave, all of that sort of thing. So the dollars can really add up. You can imagine being a restaurant owner.
Yeah, difficult, that's for sure.
Yeah.
Ben, it's Lillian Lever. Can you hear me?
Lillian, how are you?
Well, thanks. We have, in 2018, we issued a letter to our 4 casuals, to say by October 18 they would be entitled to ask for part-time work instead of casual, because there are a certain number of hours and it's pretty regular that they work. One applied for it, which is fine, but the other 3 just ignored the letter totally. And although we had asked them to reconsider it, they'd had 4 weeks to answer it, and they just haven't. One is no longer with us, but one is back under JobKeeper. And I have discussed it with her again to say, you really should be part-time. She gets quite upset and says, I was employed as a casual, I am a casual, and I am not going on to part-time. What do I do there?
That is a tough question.
Yeah.
They want to be employed on that basis. So what can you tell me about their work? Is it regular?
Yeah, she works on Wednesday, Thursday, Friday from 9 till 3. So it's 6 hours, because that fits in with her children being at school, and she's got to leave at 3 for that. What she doesn't want to lose is the loading. She's worried about that, even though I've said, but you'll get permanent holidays and sick leave for yourself or for your family. And she just wants her money to remain at the same rate.
Okay. Because, you're either a casual employee or you're not, aren't you? When you look at the case where it says, look at these factors, okay? So, you know, you've got to look at the factors, look at the indicia and say, well, you know, yeah, does she get regular work? Is it systematic? Does she have an expectation of more work? Tick, tick, tick.
Yeah. Well, I have suggested to her, because there are 3 other days she can work, and we could give her a roster that does alter around a pattern, but it doesn't fit in with her lifestyle. So she just wants the same 3 days.
Yes.
I mean, we're almost at the stage of saying, look, we feel you really are part-time, you're not casual. If you're not prepared to go onto part-time, there isn't a job.
Is she on an employment contract, Lillian?
No, she's not. She started before we had them.
Okay, I'll tell you what I would, and a very valuable employee.
Yeah, she works extremely well. We don't want to lose her.
So there is a risk there, you know, clearly, in light of this recent decision. I'm just trying to think what you might do. Okay, I mean, you don't want to lose her. You know, it's a balance here. I'd probably be looking at getting her on a contract, and you know, somewhere in that contract, clearly having it stated that you know, you're paid this hourly rate, and this is the breakdown of that, and that, you know, a portion of this 25% of your hourly rate is, you know, in lieu of, you know, is basically in payment of your entitlements. The only problem is that, you know, you can't, as an employer, you're not meant to be able to go and say, instead of you having your annual leave, I'm going to give you this money. You know, you can't do that. Okay, casual employees, I guess, are the exception. But this lady, she's not a casual employee, or potentially not. Give her a contract. Recommend that she goes off and gets her own independent legal advice. Put a letter there. You know, maybe try all of that, but it's an ongoing risk. Or you get advice from a lawyer, you know, and give it to her, saying that, you know, on what you've told us, the employee is this. You know, she's going to have to go onto a permanent contract. It's a difficult one to answer. A difficult situation you're in.
Yeah, I know.
So I would, Lillian, if I were you, I'd probably get legal advice on that. And I don't think it'll be something that a lawyer just has the answer to. They're going to have to think about it and you know, work out a plan.
Okay.
Sorry.
I might be seeing you soon.
Ben, Nadia Bartlett has also said exactly the same thing in the chat box. She said, with the same scenario where staff that are on a casual contract are entitled to become permanent, but do not want to, as they want to work on the reduced hourly rate, or on the, maybe the higher hourly rate from there. So it seems to be there's a bit of a common theme with employees that just want to stay on the higher rate, and that's why they're at casual instead of getting the leave loading and the holidays and things like that. So
yeah,
minefield.
Just say to people, it's not a question that I've been asked as of yet, and you're in a difficult situation, but I would you know, go and get advice on this, and as I said, it's I think something that lawyers will have to sit with for a little while and work out an approach. You know, they either become permanent part-times, or, you know, if they're not going to do that, you know, can we cover the backsides of employers, so that if a claim is brought against them, we can say, hang on, you know, we did everything that we could. We invited the employee to go off and get independent legal advice. We told them that they're permanent employees, we're not casual employees. We wanted them to accept this. So, you know, maybe nothing happens, but your lawyers help you to build a case against the employee in the event that down the track they bring a claim against you. Okay, so that you have a defence. That's how I would be thinking about this. Okay, and often when you go through this process with the employee, it kind of puts them off bringing a claim because they know full well that you did everything
On the waiver, yeah.
you could to get them to go to permanent part-time. So that might be the approach, Lillian.
Yeah. Okay, thank you.
Got another question here, Ben. Why are casual workers entitled to long service leave?
Sorry?
Why are casual workers entitled to long service leave? So, if you've got a long-term casual, they're entitled to long service leave. From memory, it was a case that was, once again, it was a legal case, wasn't it?
Yeah, I couldn't answer that. Actually, why are they entitled? They just are.
Yeah, there was a case quite some time ago which pretty much said that long-term employees, if you're employed on a systematic basis and things like that, you'll know the rules better than I do. They're actually entitled to long service leave, aren't they? So that's just the rules, isn't it, mate?
I'd actually have to have a good look at that, to be honest with you.
Cool. We got any other questions from anybody else of Ben or myself or of any of the other Canals guys? Here's Darren.
Oh, look, I was just going to make a general comment. Where all these rules are going is it's almost the death of businesses that do rely on casual employees in due course. You imagine if we come back to a situation where we hope we don't in Queensland, where COVID-19 forces us to shut down again. Like, it was very difficult for businesses in the, whether it's a tourism, entertainment, hospitality, all these businesses rely on casual employees. They were sort of excluded from JobKeeper unless they're long-term casuals. And now we're hearing that potentially long-term casuals with, in certain situations, are actually entitled to entitlements just like normal employees. So it's getting quite very scary out there for businesses that rely on casuals. A lot of cost involved to protect themselves, talking to accountants and solicitors. So I just hope that there's some potential legal intervention somewhere just to make this simpler, to avoid a bit of fallout from all this.
It's funny, Darren, I read somewhere, and this is a bit of political, but there was somewhere that within the government they were saying that they don't like casual employees, and it seems to be it's like a more of a way that they want business to head. I mean, not exactly a fan of it, but that's from what's happening with the legal cases and also, as you said, with the JobKeeper stuff as well. I saw a submission with regards to JobKeeper, and the government pretty much came back and it was along the lines of, we want essentially casuals to, everyone to be on permanent part-time or permanent at some point. That's the government's aim with employment.
It just doesn't suit business, it just doesn't suit business, okay? People that are making these decisions are clearly not business people. Demand for services goes up and down, doesn't it? Restaurant game, Monday night busy one week, not the next. Need to be able to get people in and out. I don't think it's a good thing. Employers are going to be far more hesitant to put people on. It's going to result in unemployment.
And you ask, as we've said here today, you ask the casual employees what they want too. Often they like casual employment. It's a higher rate. They can pick and choose some hours in situations, more flexibility.
Uni students, I mean, that's what they want, isn't it? Schools,
Yep.
Kids 15, 16, 17s, uni students.
Well, you're exactly right. I mean, you've got kids coming up to that age. I've got a couple of stepkids as well. And I mean, it's good for them. They're not locked into working all the time as well. It works both ways, doesn't it, really? Especially for kids.
Yeah.
Oh, very good. We've got no other questions from the floor at all? No?
I hope people found that useful. It was probably a bit more technical than I would have liked. Okay, if you're going to take anything away from it, it's just, if you've got casual employees, you've got to be pretty careful now, okay? Particularly long-term casuals. If they're working on a regular basis, a systematic basis, if you've got rosters in there, you know, a month in advance so they know what they're doing and all that, you know, you're running a risk, and you need to look at those arrangements.
One of the things you'd probably want to add on is one of the biggest traps that we find when we go into businesses, that a lot of businesses have an award and they like to do a flat rate, where they actually don't calculate the flat rate against the means test. And the amount of businesses that actually go out there thinking they're doing the right actually come a cropper big time when you actually sit down and do a boot test or a means test against the award. And it's just one of those things that people need to be fully aware of. If you think you are actually doing the right thing by paying people more, you need to measure it out over a year to actually work out, to actually see if it actually fits under, well, it has to meet or exceed the award. And the amount of ones I've actually gone in and done on business at the moment, 90% do not meet the arrangement. So that therefore puts them at risk.
Simon, it's a difficult process, isn't it, though? Too, you know, you can understand.
It takes us to sit down and map someone out about 7 hours, going through every single person's timesheets. To do it is not a simple task. It's expensive, but the people who think they'll cheat and go, okay, we'll just give you a flat rate of $35. The award says you should be on 28. You'll be right. We have one employer that, because they didn't work Christmas Day, put them 2 cents underneath it. If they worked Christmas Day, they would put them under, and the bill they would have got if Fair Work came in was horrendous. So it's a trap. You need to talk to your accountants about that. If anyone's on any type of payment and they think they just play a flat arrangement, always come back to the award. And with the award especially, it will tell you how often you need to test it. And as Lillian was talking about before, each time the letter needs to be sent out to get agreement that somebody has to have the offer to stay on casual is actually mentioned in each single award. Some of them are 6 months, some are 8, some are 12. And it changes constantly. That's the problem.
Minefield for business, isn't it? That's the big thing that you need.
It's a minefield. It's an absolute minefield.
Everyone needs to be on top of it as much as they can be, that's for sure. Oh, very good. Well, I might wrap it up if it's okay for everybody else. Thank you very much, Ben, for hosting or presenting in this webinar of ours. So I really enjoyed it. It gave me a bit of background information. Obviously, I spoke to you this morning as well about it. Just a bit of background information about what's actually happening in the space of casuals. It's ever evolving, as I was saying in the chat before our presentation. What casuals were when I first started here 15 years ago to what casuals are now is completely different. That includes the long service leave, which we've mentioned, and also the upcoming one with this case in particular. So thank you for running through the details of that. I haven't put in the chat box a quick SurveyMonkey survey for everyone to complete. So if you're able to spare a couple of minutes and complete the survey for us, that just gives us a bit of feedback on how the webinar went, what you liked about it, what we could improve, and also what topics we can do for later on. Bit of a plug for the next couple. So we're trying to run it on the 4th Thursday of the month. This one was the 5th, I think, but usually on the 4th. Next month we have Brent, please nod if I get this right. We have someone from Vanguard doing a property update. Not a property update, a market update. Obviously markets are ever changing at the moment with coronavirus, and obviously there's some horror stories coming out now in Melbourne, Sydney, and a few interesting ones in Brisbane as well. So it's going to have some plays in the market over the next couple of weeks. And also in September we have I think Graham Gross from Harron Todd White doing a property update. So it'll be good to have Grossy along. Always love hearing their insights on what's happening in the property market. Property market is something that affects everybody, because no matter what happens, you're in the property market somehow, either as a tenant or as a landlord or as a homeowner. So it'd be good to get Grossi's opinion on where things are heading there. But thank you once again for your attendance. Thanks, Ben. Thanks, Darren and Brent from our work also. And yeah, any questions at all, please don't hesitate to shoot it through to us, and we can direct it through to Ben if we need to. And have a safe and healthy week, and a happy few weeks until we talk to you guys next. Okay, thank you everybody, and we'll talk later.
Thank
Thanks,
you.
everyone.
Have a good day.